purpose, objectively. One scratches one's heads when one thinks of what is the purpose of the section when one sees Section 7 exists to provide for the kind of scenarios that the respondents argued for in the High Court and in the SCA. So the Section 7, as the Supreme Court of Appeal found, would be a dead letter were to accommodate those types of scenarios. So there's no purpose. Once there's no purpose, you don't even get to rationality. Because one of my favorite, I shouldn't say this, but I really enjoyed paragraph 25 of the Supreme Court of Appeal judgment, where this debate about rationality came to the fore. And if I may just read paragraph 25, because it really summarizes what we would think is the notion of a constitutional state which has legislation as part of the tools of regulating life in the country. What it says is, before this court, counsel for the respondents were unable to point to a legitimate government purpose which 61A seeks to achieve. Let me just stop and emphasize the word legitimate government purpose, because we submit there is no government purpose at all, not let alone a legitimate one. Seeks to achieve by the cessation of citizenship when a South African citizen formally acquires the citizenship of another country, save for, and this is the important one, a generalized submission that its purpose is to regulate the acquisition and loss of South African citizenship. And then the important quotes that I find very attractive. That is not to state a legitimate purpose. All legislation regulates something. That is its function. But this overarching function is not the purpose of a particular piece of legislation. To meet the standard of rationality, the minister was required to provide the specific and legitimate purpose that the provision was designed to foster. And we can't find any purpose anywhere for Section 61A to exist, let alone a legitimate purpose. And even if one could think of some legitimate purpose, we would have to think, well, now that we have this legitimate purpose, how does the particular function that operates under 61A relate to this legitimate purpose? There is no, it just doesn't exist, this kind of debate that we're having. And once that's the case, the questions of where Section 20 or Section 20 or Section 3 of the 96 Constitution or Section 20 of the interim bond, they don't feature. The only time they could possibly feature is if we go to the second leg of our challenge, which is the rights violation, and whether Section 36 is satisfied to the extent that it could be. But one of the issues is the respondents would certainly have an onus to demonstrate the Section 36 factors were present once there is to be seen as a violation. And there certainly is no evidence that the respondents put up to demonstrate any Section 36 justification. So we would submit that the Supreme Court of Appeal got it right on both legs, rationality, and one doesn't even get to Section 36 under rationality, and on the rights violation when Section 36 is not satisfied.
If we are with you that the respondent has not established a legitimate purpose, what options are open to the court?
Well, the first is an obligation on the court to strike down the legislation. In other words, declare under Section 172(1)(a) that the section fails to meet or is inconsistent with the Constitution and invalid. That's the first obligation, and not an option, it's an obligation. And we would submit that applies to both the 96 and 1993 Constitution. And secondly, you would have the various options that you could make any order that is just and equitable under 172(1)(b). And bearing in mind, the respondents have put up no evidence to suggest that an order should not be held to be retrospective or that the order should be suspended. There would be no basis for what we would submit the court to do is to revert to the default position, which is to make the declaration, order that the declaration sorts from the coming into operation of either the Constitution for February 1997 or the coming into operation of the particular piece of legislation, which in this case is October 95. So we would submit, that's why we would submit that the orders that we would suggest would be appropriate, would be what we set out in paragraph 33 of our written submissions.
And if the court is with the applicant, Mr. Katz, that 6(1)(a) is unconstitutional, then we don't get to 6(2). Or do we have to deal with 6(2)?
I remember the debate. No. Although, no, you don't, because 6(2) relates not only to 6(1)(a), but to 6(1)(b) as well. And there's been no challenge to 6(1)(b), and that relates to a person who joins the armed forces of a country while that country is at war with South Africa. And 6(2) still lives, at least for purposes of 6(1)(b). So you would not have to deal with 6(2) at all, no.
There has been a suggestion that the powers granted to the minister in terms of 6(2) is too wide and unfettered, and there's nothing to, so that would not be before us insofar as the applicant is concerned.
Well, if 6(1)(a) goes, then the difficulty with 6(2)'s, let's call it Darwood discretion point, if I may put it that way, doesn't feature for purposes of those persons who would have otherwise been hit by 6(1)(a). 6(2) might be problematic for purposes of 6(1)(b), but that's not before the court.
Thank you. Thank you, Mr. Katz. Thank you, Chief Justice.
Can I just follow on that, please, Chief Justice? Mr. Katz, I understood Mr. Plaatje's, I mean, this is a question of objective validity, but I mean, we did discuss Mr. Plaatje's position, but as I understand his position, he thought that if he marries a British citizen, he acquires British citizenship surely through, purely through marriage. Is that correct? He thought so, but it wasn't so.
Well, no, there are two questions, if I may. Let me just try to understand the question. The one thing is, he thought, well, he obtained British citizenship. However he did so, is not relevant from a South African law point of view. Well, it might be, I suppose, if one looks at the carve-out of those persons who acquire the foreign citizenship by marriage.
It might be. It might be.
But we can't, he might have married, you see, we don't know. And we can't know. A South African might marry a foreigner and obtain the foreign citizenship of that foreigner without it being through marriage.
Yes.
We don't know what the foreign law is. So
okay, let me ask you directly. I mean, that's not really the point. The point is this: as I understand it, when he became aware that he doesn't really qualify for dual citizenship after he joined this group and read their online articles and blogs and discussions, he then, in sometime in 2015, voluntarily gave up his citizenship because of that belief. Am I right? That's what the papers say.
Yeah, well, yes.
That's what he approached the South African embassy, explained his position, and he voluntarily gave up his South African citizenship. That's what the papers say. Am I right?
I'm just worried whether he says it in those terms. So his affidavits on page 47.
Yes.
And he was insistent on obtaining or retaining his British citizenship.
Yes.
And his question was, he had a Hobson's choice as to what to do.
Yes.
From his perspective. So I'm not sure that he gave it up. I thought, as I discussed with Justice Theron, that from the respondent's perspective, he automatically lost his South African citizenship. Whether he did
look at paragraph 20, page 51.
Yes, I'm there.
Can't be clearer than that.
Yes.
He says a determination of citizenship, but he also says that they then told him he can't renew his passport, and he was basically forced to give it up. So he didn't voluntarily give it up. It was by operation of law.
That's what I discussed with Justice Theron. Correct. Yes. So it wasn't that he had a Hobson's choice, but he chose one or the other.
Yes. Can I ask you, did I misread the papers? I thought somewhere in the papers, while this matter was being opposed in the High Court, that Home Affairs said that they have no in principle objection to dual citizenship. Did
That's
I
correct.
misread that, or is there somewhere in the papers? Because when I read it the first time, I thought I saw it, and when I reread it, somehow I couldn't find it.
No, it's
Can
in
you
the
remember?
answering affidavit. It's in the answering affidavit where Home Affairs say in terms, well, they don't say that they don't. They say Parliament has no objection.
Parliament, yes. Sorry, when I say they, I mean
Parliament. That's
government.
correct.
Parliament, yes. Parliament.
Yes, they
Can
do
you
say
point me
that.
to the place, please, Mr. Just to help me,
Yes.
because I remember reading it, but then I couldn't find it.
I do apologize. Yes.
No, I'm coming down suddenly on you. Please take your time. I'm sorry. It's just for
No,
my
I should know
identification.
the papers better than, I should. I mean, I had it marked and it's the top of a particular page. I'm looking for the particular page.
We could always, Mr. Katz, if other colleagues have questions, you could ask your junior to have a look, and then we could come back to it if other colleagues have questions. I don't want to hold up the hearing. Thank you.
Yes.
The junior can perhaps look in the meantime.
Mr. Katz,
Justice.
in a matter where the court is engaging with the justification and analysis under Section 36, and there is no evidence from the state on justification, or there's very little evidence on that subject, the court does not throw its hands up in the air. It still tries as best it can, and this is what the jurisprudence says,
Yes.
to still see if there is any possibility of justification.
That's to understand the law, correct?
Yes. Now, I'm interested to know what the position is with regard to a rationality challenge outside of the Bill of Rights. Does the fact that there is no evidence on rationality from the government mean that the court must just accept that, or does the court treat this similarly as it does with the justification exercise under Section 36?
Yes. As we understand it, the similar principle applies. The fact that a respondent doesn't put up a legitimate purpose or link that legitimate purpose to the means used doesn't mean the court must put up its hand and say, well, therefore it's irrational. The court must still nevertheless look and see whether the court objectively can determine whether there is a legitimate purpose and whether the means used through the legislation achieve that legitimate purpose. And we submit that the same proposition applies. That's how we would see it.
Thank you then. With that in mind, I'm interrogating this scenario in my mind. The proscription of dual citizenship is not an isolated phenomenon, isolated in the sense that it's in South Africa's Section 6. I've often heard, apologies if I sound like I'm testifying from the bench, but I've often heard, and in fact, I think that's the point being made by the amicus as well, that a good few other countries also proscribe dual citizenship. Has the applicant in this matter interrogated the question why other nations also proscribe dual citizenship?
Well, may I answer on two levels. The South African Parliament has decided not to proscribe dual citizenship, in the sense that dual citizenship is permitted. The Act makes that clear, quite apart from what's stated in the affidavit. My junior, by the way, says it's paragraph 50, but there's another paragraph which he hasn't identified on this question of where the affidavit say that Parliament hasn't got a difficulty. So the first answer is Parliament hasn't proscribed.
But the point of departure is a proscription, and then that the minister may exercise a discretion is more an exception than the rule. The point of departure is a proscription. So I would suggest that let's forget the exceptions and proceed from the premise that says there is a proscription. And my point is, my understanding is that other nations also have this as well. And this, to my mind, might be of relevance to the question of rationality, especially if, as you do, you accept that the court is not bound by the evidence or lack of it proffered by the state organ concerned.
No, I take the point, Justice Malanga. On the assumption, well, let's put it this way. On the assumption, and again, I'm arguing off the assumption that there is a proscription on South African citizens holding dual citizenship, would it not be rational, well, if that's the goal, that's the legitimate purpose of the legislation to deal with that proscription. The question then arises, well, is 6.1a read with 6.2 an implementing tool that is rationally connected to that legitimate government purpose? I suppose that's how the question would be framed.
No. I want a response as to the possible basis why other nations would also have a problem, even if there are exceptions, but an initial problem with dual citizenship. And I'm asking that because, who knows, based on why those other nations have this proscription, one may be able to say, well, this is actually justified. There is actually a rational connection. Especially because you've accepted that we don't have to look to the state organ concerned only.
No,
we may look outside of that. So why do other nations proscribe, even if with exceptions, dual citizenship? Has the DA looked into that at all?
Well, we haven't, in the sense that we didn't need to, for the reason that we articulate, that even if there is a legitimate purpose, and the question then becomes, is the means used to achieve that legitimate purpose, is it rationally connected to that legitimate purpose? So is 6.1a in its form rationally connected to the legitimate purpose of proscribing dual citizenship? That's why I wanted to put the question to you slightly differently. And the answer is, we submit that it's not rationally connected, and therefore the question doesn't arise as to why would that purpose be legitimate. So I'm assuming that it's legitimate, that where there is a proscription on dual citizenship, I'm assuming it's legitimate for purposes of the debate. We haven't looked into whether it is legitimate or not, because even if it is legitimate, 6.1a doesn't achieve that which is sought to be achieved. Let me just go further and say a legitimate purpose must be seen in the history and the light of a particular country, and to look at why other countries and how other countries.
If we were at section 36(1), I would immediately say that's not the position, because because section 36(1) actually expects us to look at other open and democratic societies. So if we were at 36(1), I would take issue with your submission. But now your main argument is outside of 36(1).
We're not in 39.2. It's 13. Yes, 39.
Please continue.
Yes. I mean, 36.1 kicks back to 39.2. We don't have that here because we're outside the bounds of 36.
Okay.
But I wanted to go further than that. In South Africa, citizenship is of a particular. It's got a particular. This court has said it over and over. It has a particular taste, a sour taste or a positive taste, depending on how one sees it. And therefore, what might be good for some other country would not be legitimate for South Africa in the context of the taste of citizenship in South Africa. It's got a particular history, and this court has said it. It's in our heads of argument, the importance of sort of the badge of honor. And the question is, if there was to be a proscription, to have that badge of honor and the taste of citizenship taken away in the way it's done by way of 61A, we would find not to be rationally connected to that prescription. Therefore, one doesn't even get to the legitimate purpose. But we still submit whatever that legitimate purpose is. And I'm really sorry, Justice Majid, that I can't find this where it's said in the answering affidavit, paragraph 25. I'm told not that paragraph 25 of the answering affidavit where there is a firm, a definitive statement to say no, it's not 25. I'm not sure where it is. I must apologize for this because it jumped out at me where.
Can I suggest that you finish your answer to Justice Madlanga, because I've got a question on paragraph 50, which is the only place where it is actually.
Yes, sorry, Justice.
Please finish with Justice Madlanga before I get to that.
Yes, Justice Madlanga.
If you are done with your last response, that was my last question. Thank you, Mr. Katz. Thank you.
Yes.
Oh, thank you. May I, Chief Justice? Paragraph 50 is the one I had in mind. That's the only place that I thought I saw it and I couldn't pick it up the second time. Dual citizenship is permitted by the Act, but it says that's permitted in terms of Section 6.2. Now, even if one accepts your reasoning and argument for purposes of a judgment, that 61A falls doesn't pass muster because just basically simply on the basis there's no legitimate purpose. So you don't even get to rationality and justification analyses. Mustn't one in any event then still interrogate Section 6.2 for the limited purpose, Mr. Katz, of asking if the Act permits dual citizenship based on the minister's discretion, one must deal with it, and just prima facie, it seems to me the SA is absolutely correct. This is an untrammeled discretion, undefined. Yes. It's completely devoid of Audi, any administrative justice, and so on. But the point is one must interrogate Section 6.2 for that limited purpose, because it seems to me, and as Justice Madlanga has correctly said, one must look to see where there could be any sort of purpose advanced in the Act. In other words, Section 6.2 for giving for dual citizenship being permitted by the minister, by a member of the executive.
Yes, the Supreme Court of Appeal in paragraphs 31 and 32 of the Supreme Court of Appeal judgment makes it clear that 6.2 adds to the arbitrariness of the nature of 6.1a, and says it reposes the minister vague and undefined discretionary power in relation to the retention of a fundamental right inextricably linked to other fundamental rights. And it mentions the other rights, and then it says, the SCA says, the minister is thus afforded unconstrained discretion without any guidance as to how such discretion is to be exercised. And it goes on. Clearly a violation of the kinds of ideas that this court, as long ago as Dawood, put in place. So
the only reason why I'm asking that is because when you were engaging with Justice Theron, you said, once we make a finding on 6.1a along the lines that you advance, it's not necessary to look at 6.2. I'm saying to you, it may be necessary in a judgment to look at 6.2 for this limited purpose only.
Yes,
the finding.
Yes, I think my debate with Justice Theron spoke to the order, and I think her question was rather, were 6.1a to fall foul of the Constitution, what would the nature of the order be, and should Section 6.2 be tampered with? And my answer was it shouldn't be, because it's as far as the order is concerned, because it still can continue to live because of 6.1b. But as far as the point that Justice Majid, you making to me, we support the reasoning of the SCA in paragraphs 31 and 32 of its judgment.
Thank you. Thank you, Mr. Katz. Thank you, Chief Justice.
Any more questions? Yes. I had lost connectivity, Chief Justice, so I apologize in advance if I repeat a question that's been asked, because I heard Justice Majid ask about the order. I wanted Mr. Katz to deal just with the question of retrospectivity and how practical it would be to go back to 1995.
Well, we make two submissions. The first is the default position is to go back to 95. And the only time that a court would deviate from the default position would be if there was some either evidence or argument about the potential disruption that retrospectivity would entail. And there isn't. There's no evidence and there's no argument that there would be any disruption or potential disruption. So we would submit the default position is the one that should follow. Also, quite apart from that question, the issue arises, well, an effective remedy to those who may be affected. And somebody such as Mr. Plaatjes, when else could it be? It could either be, the order should either come into operation immediately rather than be retrospective, but that would mean that many citizens who lost their citizenship in an unconstitutional manner would not get the benefit of the order, and that would submit is not in the interest of justice, or not just and equitable, as the term is stated. I'm still very bothered, but I'm sorry to go on. I'm still very bothered. I can't answer Justice Majid's question because I know that it said that it's paragraph 50 of the answering affidavit where it is suggested that dual citizenship is not a problem, but I just can't find it, and I've gone through it over and over. And I know I've seen it, and he's right. I just can't. Anyway, maybe I could, if Chief Justice, if you'd give me
You can
permission,
continue looking for it, and even after the proceedings, you can send us a note telling us
that's
where
what I wanted to
it
ask
is.
you. I'd ask for permission to do that. Because I know I'd seen it in just the same way that Justice Majid had seen it. I've also seen it where it said Parliament, and it uses the word Parliament in particular. I've just lost it. Anyway.
Yes.
Sorry,
My last
Justice
question,
Durant.
Mr. Katz.
Yes.
Yes. I know I'd asked you earlier about loss and deprivation, and I don't mean to dwell on it, but isn't the distinction important, especially also if one has regard to Section 8(2) of the Citizenship Act, which particularly makes reference to deprivation?
Yes. I'm just.
So wouldn't it be important to understand what we're dealing with? Are we dealing with the loss of citizenship? If there's a distinction, firstly, and what are we dealing with here and the effect of the distinction?
Yes. Perhaps, Justice Durant, I do apologize. Perhaps you should help me. I mean, deprivation is an act by a particular office bearer, the minister. That's Section 8. Whereas Section 7, there's no act by any official such as the minister which causes the loss. And I think that's something it's part of why 61A doesn't serve a legitimate purpose in the sense of I've already articulated. So I'm not sure.
Thank you, Mr. Katz.
So just to turn on the real question is, I'm not just sure where, and I apologize, where that debate would take our argument. Anyway, so Justice Durant, I do apologize.
Is a loss of citizenship, does it equate to deprivation of citizenship?
No. Well, it doesn't. Well, it's not the same. They don't generate the same concepts. So deprivation is an active step by a government official to deprive somebody of something. Here, loss in the sense Section 6 talks to is automatic loss. It just happens by operational. There's no government official making any decision to deprive you of citizenship. I suppose one could say loss in Section 6 is...
So, if I understand your argument then, the loss of citizenship does not amount to a deprivation under Section 20. So it's not a contravention of Section 20 of the Bill of Rights. Because Section 20 says that a citizen may not be deprived of citizenship.
I understand.
So if there is that distinction, it means that a citizen can lose citizenship.
Well, losing...
And then, but not through an act of deprivation and not fall foul of Section 20.
Well, I want to answer it like this, and I don't want to how can I put this? Jump onto something that I have argued in a different way. Loss for purposes of Section 6 could be and should be considered as deprivation of citizenship by Parliament rather than by a minister. So it's deprivation. That's why deprivation and loss might have two different meanings in different contexts. So when Section 6 uses the word loss, that loss is a deprivation a la Section 20 by Parliament, not by a minister. But that's why I say it's a distinction without a difference. Deprivation in Section 20 could include the loss by way of operation of law, which Parliament has affected, but not by a minister.
But there must be a reason why in Section 20, the legislature uses the word deprivation, and why in Section 3, the word loss is used.
I accept that. I'd have to accept that. But I say for purposes of, so in other words, the question then I suppose is this: on the basis that we come home on the irrationality of the section, that it doesn't serve a legitimate government, it doesn't serve any purpose, let alone a legitimate one, and the means and aren't connected to the means don't justify the ends. The question then must be posed: well, is the section one which violates Section 20, which uses the word deprivation, and this is not a deprivation? Again, I'm going to come back to my initial submission, which I know the High Court didn't find favor with. The loss contemplated by Section 6, we submit, would fall under the umbrella of the Section 20 deprivation. And I understand the question that Section 3 also talks to loss, but I stand by the submission that Section 6 can be found under the umbrella of Section 20's deprivation.
Why can't Section 6 be found under the umbrella of Section 3 of the Constitution?
It could in principle, but it could also be, we would submit that it also would fall under the umbrella of Section 20.
And I don't mean to unnecessarily press you, but if you look at Section 3.3, it says national legislation must provide for the acquisition, loss of citizenship.
No, it does. I can't get away from that.
And doesn't that what Section 6 does? It provides for loss, doesn't provide for deprivation. And for deprivation, we look at Section 8.
I take the point, Justice Theron, but I'm going to stand by my submission that Section 6 does sort under Section 20. I understand the proposition. I understand that that it could be argued that Section 6 sorts under Section 3, not Section 20, but I would submit that it applies to both.
Thank you, Mr.
But then
Katz.
the other, I mean, Justice Theron, in interpreting Section 6(1)(a), we would submit that the citizenship right, which is a gateway right, we would submit should be given a generous and a broad meaning. And if there are two different meanings to be ascribed to it, I know the general rule will be that, well, you choose the one which least interferes with, or which better promotes and best promotes constitutional rights, the Bill of Rights in general. And we would submit that however one interprets 6(1)(a), it would be better from a constitutional rights, Bill of Rights as a whole perspective, the gateway rights argument, that it be regarded as falling under the Section 20 umbrella. That's the point. And then the question of Section 36 kicks in, rather than to exclude the 6(1)(a) loss from Section 20 application at all.
I can understand why the applicant would press the Section 20 argument, but thank you, Mr. Katz. Thank you.
But in any event, Justice Theron, I mean, the real issue is, well, I suppose the court could ask the question, do you need to go there bearing in mind the rationality debate, which is a different debate? So, we won on both legs in the SCA, and there's no reason, well, we would submit that we should win, that both legs should be confirmed, but it's not necessary if the section is struck down on the basis of either or both legs for purposes of the debate.
Thank you, Chief Justice. Thank you, Mr. Katz.
Any more questions, colleagues?
Chief Justice, can I just ask Mr. Katz something with regard to 6(1)(a), please?
Yes.
Mr. Katz, You mentioned that you can't interpret section 61A without looking at 2. Is that right?
I'm not sure I said that, but I accept that for purposes of the debate, yes.
Yes, because 6.1 starts off with the word subject to the provisions of subsection 2.
Yes.
So you have to look at 2 as well.
Yes.
Now, the way I read 6.1a, it involves a voluntary act.
Yes.
Isn't that right?
No, it does.
And
That's correct.
Yeah. So if a citizen of this country is embarking on some act to do away with his citizenship of this country, he can, in terms of section 2, then prior to that loss, apply to the minister for dual citizenship. Isn't that right?
That's correct.
So I'm struggling to see why the section should be done away with in those circumstances.
Well, I'm going to rely, I'm not sure how to answer other than to suggest that the reasoning, very full and detailed and thorough reasoning of the Supreme Court of Appeal is correct. The first reason is that there's no purpose that is served by 6.1a if a person wishes to, open quote, give up their citizenship. There's no reason why they can't rely on section 7, the renunciation section. And the Supreme Court of Appeal makes the point that if the person that 6.1a contemplates is a person who wishes to give up their citizenship by, as you put it, Justice Seagoman, a voluntary act, what's the purpose of section 7? And becomes redundant. So therefore, section 6.1a must contemplate people other than the section 7 people. And what's the purpose of the section? And the Supreme Court of Appeal found there was no purpose, let alone a legitimate purpose. So that's the first answer. The second answer is the one that I've been having a debate with Justice Taron about, that it's a loss which is under the umbrella of section 20 deprivation without justification being satisfied under section 36. So those are the two legs of why we say that section 6.1a falls foul of the Constitution.
Yes. Yes, thank you. Thank you, Chief Justice.
Colleagues, any more questions?
And Chief Justice, perhaps I should just, my junior reminds me to add a point which is made in the Supreme Court of Appeal's judgment that 6.1a, interestingly, and it's a point that's always, when I read it for the first time in 2016 for the purpose of this case, it always struck me that which is contained in paragraph 30 of the Supreme Court of Appeal judgment is should be of somewhat concern. And that is that even those people who've lost their South African citizenship by virtue of the implementation of section 6.1a, they themselves might not know that they've lost their citizenship, but also, and more importantly, or as importantly, the government might not know when or how it happened. And the argument that I'm pressed at the Supreme Court of Appeal hearing was that there are certain positions, a judge of the Constitutional Court, a member of Parliament, a whole range of administrative officials who in this country, who, in order to be in the position that they're in, need to be South African citizens. And they wouldn't know, and Home Affairs wouldn't know, and Parliament might not know that by virtue of 6.1a, they actually are no longer South African citizens and wouldn't be entitled to be in the exalted positions they occupy within the South African public sphere. So that's something that my juniors reminded me to emphasize, but that is contained in paragraph 30 paragraph 30 of the SCA judgment, page 173. And that goes to its irrationality as well.
Mr. Katz, by the way, the portion that you was looking for is in exactly that paragraph, and that's the thing I also read, 173. Second line of the second line, the legislature is not against dual citizenship, we were told.
Yes, that's right. That's right.
That's what you were looking for, and that's
Yeah.
what I thought I read, yeah.
That's it. Was the
Thank
top
you.
of the. I knew it was at the top
Yes.
of the page. I just couldn't.
Yes.
But
Yes.
yes.
All right.
Yes, I've got a feeling it was in our learned friend Mr. Macquarie's heads of argument at both the High Court and SCA level. That's where the sentence comes from.
All right. Justice Chip, do you have a question?
No, I don't.
All right.
Thanks, Chief Justice.
All right. Thank you very much for your submissions, gentlemen. The court will take time. Judgment is reserved.
Thank you
Court
very much.
adjourns.
As a pleasure of the court.
Today's proceedings have concluded. The host will now terminate the meeting. Thank you.
This